would consider the biggest one is that a lot of stakeholders have said that, you know, the amount of discretion or the level of discretion that is left to the regulatory body may increase the risk of infringement on constitutionally guaranteed rights and freedoms, particularly the right, you know, of the freedom of association that has been guaranteed all citizens of Nigeria. The second, you know, from my reading of the concerns raised is that there are certain groups, particularly religious groups, that prefer to be excluded from the provisions that have to deal with the removal or and replacement of trustees with interim managers. And then the third, you know, kind of broad, what I've seen in the papers and from other analysis is what I would, you know, what is being described as the excessive focus on the assets and resources that are owned by organizations. And I think, you know, to be clear, the particular interest here is with the provisions of the law that have to do with incorporated trustees in terms of some of these provisions that have been mentioned. Now, on the flip side, though, there are also organizations that and individuals that believe that similar laws are, you know, in existence in other jurisdictions, and you know that those laws are applicable to similar types of organizations in these places. So, really, you know, my thinking is that both sides of the conversation bring unique perspectives, and those perspectives don't always align. So, I would like to think that what is interesting about the conversation that we're having this afternoon is that it would really offer the space for different stakeholders and organizations and individuals to really bring their perspectives, you know, in terms of the merits of the new law, as well as any potential challenges that are seen. But most importantly, also to think about the way forward in terms of, you know, what recommendations can help to take care of any of the potential gaps in the law that might be seen to be problematic. Spaces for Change has done a really good job in, you know, assembling a very strong group of speakers and stakeholders, you know, who would offer perspectives this afternoon. So my role is really to moderate and call each speaker to offer their views. I will encourage speakers to keep their interventions as short as possible so that we can have more time, you know, for discussion amongst all the participants. So to kick us off, I'm going to call on Joe Powell, the Deputy Executive Officer, Chief Executive Officer of the Open Government Partnership, to offer a few goodwill remarks. Over to you, Joe.
Thank you so much to the moderator, and sorry, I wasn't sure whether that we were speaking at this point. So I just a quick context, I guess, from a global perspective, and really we're here to listen and learn from all of you and understand the situation better. But the way that we come at this issue is we have 78 member countries of the Open Government Partnership. And one of the reforms that now about 25 of them have been implementing is a move towards public disclosure of company ownership as a means to tackle money laundering, tax evasion, corruption, lead capture, and so on. This was a reform that was given a big push in the 2016 London Anti-Corruption Summit, which was the same place where President Buhari signed Nigeria up to the Open Government Partnership. And OGP in Nigeria, as I'm sure many of you on the call know, is a government and civil society endeavor. So there are hundreds of civil society organizations involved. The co-chair of the OGP Nigeria is from civil society alongside Minister Prince Clem Agba. So when this law was passed, of course, we were very interested because it contained some provisions on creating a public register of beneficial ownership that could be very helpful in the fight against corruption. But at the same time, we were very keen to learn more about some other aspects of the bill that may have some impact on civic space or the operation of civil society. So I guess we want to just listen and learn and understand what are the good parts from this bill, what are the parts that we could be challenging, and then what's the way forward. And really, we're here just in support of the Nigerian government and civil society to support you as you best see the way forward. We're not a body that imposes standards or our opinion on anyone. So we're really here to listen and learn today. And if we can share experience from other countries, we're also very happy to do that through the conversation. Thank you.
Thank you, Joe. So I'm going to call on Victoria Ibezim to share her, her presentation that would focus on a comparison between the original CAMA law that was, designed in 1990 and the recently signed one. Just to say that if you have questions, you can enter your questions in the Q&A box. And, if it's also possible to introduce yourself using the chat box, that would be, greatly welcome. Over to you, Victoria. I think you need to unmute yourself, Victoria. Your microphone is not on.
Oh, great. Thank you. Thank you, Dabazaki. Thank you, other fellow panelists and all the participants. I greet you from the very rainy city of Lagos. My interventions will be focusing on some of the key issues and arguments that have been rising since we issued our briefer on CAMA. Like Dabazaki mentioned, our briefer has already, analyzed and compared the previous provisions to the current revisions that have been made. So I will just focus on more current issues that have arisen since then. There are 4 arguments that we have spotlighted from our review of a lot of reports that are online and offline. The 4 arguments that we've picked up as follows. So I will respond to those 4 arguments. The first is that CAMA consolidates the government's efforts to combat illicit financial flows, which also resonates strongly with what Joe just said a short while ago. So the flip side of that argument, that critics of the latest revisions in CAMA are afraid of probity and accountability. The second issue we have identified is the comment relating to the troubling sections of CAMA being copied from UK charity laws, especially as enforced by the UK Charities Commission. So if it's applicable to the UK, why not Nigeria? The third argument is that CAMA will strengthen corporate governance in non-profit entities and make trustees more accountable. And the last argument out there is a question about what actually is feeding the persistent restrictive legislations targeted at the NPO sector. What are the drivers of too many NTM restrictive laws targeting Nigerian NGOs? So I will start with the first one, which is that the new CAMA will combat illicit financial flows. I would just like spotlight just a couple of provisions. Under the 1990 CAMA law, the obligation to disclose beneficial own interest was limited to public companies. But CAMA 2020 no longer requires that distinction for disclosure to be required by a public company or a private company. Disclosure is now mandatory, whether it's a public or private company. I also like to refer you to section 119 and section 120 of CAMA that talks about significant control. Persons who hold significant control in any type of company at all, they are required to disclose particulars of such control within 7 days of acquiring that control. And the company, when that disclosure is made, the company will inform the CAC within 1 month of receipt of that information, put it in their annual returns, file it to the CAC, and update their register of members with the appropriate details. So by this section, CAMA now mandates disclosure of beneficial interest in all companies, even where such interests are held through nominal holders or in trust. Then I made a lot of reference to significant control. What does significant control mean? Section 120 sub 2 of CAMA makes a reference to what that means. You are deemed to have significant control or a substantial shareholder in a public company if you hold either by yourself or through your nominees shares that entitle you to exercise at least 5% of unrestricted voting rights at any general meeting of the company. Then I also refer you to section 374 sub 6, where public companies are now required to display their audited financial accounts on their website. This is not new because it aligns with an existing requirement of the Nigerian Stock Exchange and the Securities Exchange Commission. Then another interesting provision is section 278 that talks about disclosure of multiple directorships held by any person. So in addition to disclosing your multiple directorships, CAMA now prohibits individuals from being a director in not more than 5 public companies. Then there are also new provisions that talk about, now recognizes virtual meetings, shareholder meetings cannot be held online, then it also separates the roles of the chairman and executive officer of the company. So will the new CAMA combat illicit financial flows? The question is, this combination of provisions I described will help to mask the true human and legal persons behind corporate entities. It will come, at least uncover the quantum of interest, the power or control that they wield in those entities, and reveal situations of potential conflicts of interest. So by so doing, these amendments, they aim to increase transparency. They can combat asset shielding, which is a relevant component or relevant measure for combating illicit financial flows. So to that extent, yes, CAMA, the new CAMA will help combat illicit financial flows. But coming back to Part F, which relates to non-profit, I deliberately read out those sections for you to see the wordings and framings of those relevant sections that I just discussed. The framing suggests that they apply to private companies limited by shares or to public quoted companies. So why do I draw these inferences from? If you look at section 119, if you look at section 120, they talk about disclosure of significant control. And that significant control is determined by the weight of shares held by that shareholder, 5% to be specific. Part F of CAMA, the entire Part F of CAMA does not contain any such language or requirement that suggests that the sections are applicable to beneficial ownership and the like apply to non-profits. I say this with a note of caution in the sense that we are yet to finish reading like the appendix and the interpretation section. We've read the other part, but interpretation section to know if there is any section where this is expressly stated. But by Part F, there is all those provisions I just cited on beneficial, they do not apply to Part F. That is companies incorporated by incorporated trustees. So finally, non-profits or bodies registered as incorporated trustees, they do not have shareholders. They do not, even their trustees do not have voting rights. They do not have weighted shares. They do not have shares held in their name or by their nominees in that sense. So non-profit entities are structured differently from profit and private public companies or private companies limited by shares. So in conclusion, I think it's unclear whether the illicit financial flow provisions of CAMA even apply to non-profits in the first place. Let's go back to the second question, which is that this law applies to UK. Why not in Nigeria? I think this flows from the assumption that any law that is practiced in the United Kingdom is probably best practice. Again, best practice is not location specific. The UK Charity Commission, let me just describe fairly some of their broadly the functions of the UK Charity Commission. They regulate and register charities in England and Wales. They run an online register of charities. They provide full information, including financial information about all registered charities in UK and Wales, in England and Wales. And they also investigate accusations of wrongdoing by registered charities. Let's compare the functions of UK Charity Commission with Section 8 of CAMA. The Commission's functions, among other things, to regulate the formation, registration, and winding down of companies, to establish and maintain companies' registry and offices in all the states of the Federation, to arrange and conduct an investigation into the affairs of any company, whether limited by guarantee or incorporated trustees or by shares or corporate companies, where the interests of the shareholders or the public so demand. So if you look at the provision of the sections or the functions of UK Charity Commission and the provision on this and the functions of the Nigerian Corporate Affairs Commission, there's absolutely no power conferred on the UK Charity Commission that the CAC does not currently have. And there is no function that UK Commission currently confirms that CAC is not empowered to do by statute. So on the issue of whether laws apply to UK or they apply to Nigeria, I think I must emphasize there's a difference between advocacy for better regulation and advocacy for procedural limitation. When people are saying this law appeared in the UK this or that way, I think they're saying this is the procedure for how it's done in the UK. Let's just copy the procedure, not the actual regulatory reforms. I think the ultimate focus should be on results and not just consequences or style. So the begging question is, what makes UK Charity Commission able to deliver the kind of results its counterpart CAT is not delivering? From my perspective, one answer to that could be that there are other tiers of control that build public trust and confidence in the regulatory system in the UK by checking the exercise of arbitrary discretionary power. There are administrative, parliamentary, and judicial controls in place that make it harder for officials to bend the law, either for pecuniary purposes or to target specific groups that hold the government to account. So in a system where state executive flagrantly disobey court orders, they abduct critics from their homes in broad daylight, and citizens are disappeared for over a year without any state agency making any serious inquiry into the disappearance of that citizen, then overbroad provisions like the new CAMA would definitely arm such overbearing state executives with a strong weapon for legitimizing acts that survive the rule of law and shrink the civic space. The third argument is CAMA will improve and strengthen corporate governance in non-profit entities and make trustees more accountable. I think one major concern with that section is that it was copied from the UK law and imported into local legislation without matching the provisions to contextual realities here. Let me give you an example. Part 39 is the most controversial section and talking about removal of trustees on account of a number of infractions. So apart from religious bodies like churches, trustees are not first-line responders in non-profits. I'm speaking for NGOs now, I'm being narrow. And as such, trustees are not involved in day-to-day running of incorporated trustees. The board of trustees is the highest echelon of decision-making and oversight over the management of the association. Therefore, where the management has gone out of track, that's where the board of trustees as an oversight mechanism then intervenes to investigate and address the challenge. So if you look at the new CAMA, there's no enabling association to use those internal mechanisms of control that are take corrections when the activities go off track. Then it denies the registered association the opportunity to use the internal mechanisms to self-correct or address any perceived or actual wrongs. External intervention should only be initiated as the last resort where mechanisms have been inefficient in dealing with corporate governance issues. So I also want to add that most associations have a minimum of 5 trustees, 3, if one has gone off track, it can be removed and other 3 continue to function, obviating the need to impose interim managers. I want to add that that provision also tends to make the assumption that the non-profit sector has either operated without adequate regulatory controls or has no regulatory controls. I think what the problem is that low compliance compounded by poor enforcement of existing legislation, they've been misunderstood to mean regulatory inadequacy or no regulation at all. Long before CAMA, NPOs file annual returns to the Commission where they submit financial statements detailing their inflows and outflows, their expenditures within a year, and other information, and more particular details of the same information. They submit it to SCUMO, they submit to NFIU on a weekly or monthly basis, depending on whether they are cash transaction report, suspicion transaction reports, as the case may be. SCUMO and FIU by statute are empowered to conduct periodic on-site and off-site inspection of NPOs. And this, and again, SCUMO also conducts supervision of NPOs, and they require NPOs to appoint AML CFT compliance officers. NPOs also file personal income and taxes to FIRS. They also interface with commercial banks where they are subject to all banking regulations. So all these regulatory controls have always been in place. So I find it's hard to match it with the argument that there is need for more and more regulation or there's no regulation at all. Then the last question is what is feeding these persistent restrictive legislations? Please, with due respect to my colleagues, I know some senior colleagues from GIABA are here, some senior colleagues from SCUMO are here. I would like to make some reference to some of the drivers of the persistent restrictive legislations. I will make a reference to the rating, the kind of ratings Nigeria has been receiving from FATF and JABA in particular. Nigeria has not received a lot of positive ratings, and as a result, they're under pressure to conform to international financial regulations, particularly FATF standard. The result is that state actors often go overboard, trying to demonstrate their seriousness to fight corruption, combat money laundering, and terrorism financing. Let me give you clear examples. In 2008, JABA published a mutual evaluation for Nigeria on anti-money laundering and combating the financing of terrorism. JABA followed up with 2008 reports, with 7 follow-up reports for each year from 2009 to 2015. Each of them reassessing Nigerian AML compliance based on improvements that have been made. Then Nigeria enacted quite a number of laws, particularly the money laundering law, set up SCOMO, revised the Terrorism Prevention Act, and other legislative changes. General assessment a bit changed, but the rating of NPO sector has remained constantly non-compliant over the period. So the second evaluation happened last year, following the on-site visit to Nigeria. The final mutual evaluation report is not out, but feelers we are getting from civil society suggest that the ratings again are not positive. So governments, including Nigeria, they're responding to FATF low ratings with tighter legislative measures, which of course have implications on the wider local economy and specific impacts on the space for MPO operations. So in sum, as long as countries continue to have low ratings, restrictive measures that shrink the civic space may likely continue. And this is from our perspective, and I think I made the same intervention a few days ago at the GIZ Forum on Negative Financial Flow, trying to establish the connection between these consistent low ratings and shrinking civic space. So finally, what's the way forward? I think a lot of ideas are already out there about what the way forward is. Taking a cue from the Vice President, he has advised that those are aggrieved, we should approach the National Assembly for amendments. I think legislative amendments must be backed by rigorous analysis of the extant laws and the kind of collaboration Spaces for Change and ECNL, supported by Ford Foundation and Fund for Global Human Rights. The kind of collaboration we've had shows the example of like how North-South synergies can spur innovation, knowledge building, and rigorous evaluation of local law in order to influence policy advocacy for legal reform. Another option is to get the president to revoke assent or send the legislation back to the National Assembly to address key concerns. The international community, most of you here play a huge role in the sense that you can use subtle advocacy and diplomacy to get our stakeholder concern across the decision makers and influence policy reversal. And the last one is those that are saying no can consider legal action. Then I think the international and local stakeholders have a role to play because they need to find willing plaintiffs, willing defendants who are willing to match it with courage to take the their concerns to the court. Because by Section 6 sub 6 of the Constitution, citizens have a right to challenge legislation that they find inimical to their interests. So I will stop here and take questions afterwards.
Thank you, Victoria. I think that was a very comprehensive intervention. A number of things stood out for me, but I'm just gonna hold off until we come to this question and answer section. Just to say again, if you have any questions, please enter them in the Q&A box. The chat box is, I encourage people to introduce themselves there, but if you have questions, comments, please enter them in the Q&A box. I'm going to now invite Vanya Skorik from the ECNL to make her intervention.
Thank you so much, and good afternoon or good morning to everybody. We're really happy to be joining here. And let me start a little bit with the broader context, because ECNL has been working on this topic for a number of years. And we do know, and there's ample evidence, that nonprofit organizations around the world face operational and legal restrictions due to anti-money laundering and counterterrorism regulations. This has unfortunately often had a negative effect on their abilities to actually implement the activities and protect the needs of beneficiaries, especially in the crisis or conflict areas. And we know, and we have seen a number of times, that sometimes the good intentions and the common goal, and that is to avoid and to limit the abuse from money laundering and terrorist financing, lead the governments to overregulate or to copy solutions from other countries that do not necessarily work in their own context. And sometimes the governments treat all sectors the same as one size fits all solution. However, we do know that the FATF requires a risk-based and targeted approach. And we also know that the nonprofit sector cannot be treated the same way as other sectors, especially the business sector. Now, the reason for that is because the nonprofit sector actually enjoys the international and constitutional protections, a number of them, specifically the freedoms of association, assembly, freedom of expression, belief, and the right to participation. And that means that any measures introduced to combat illicit financial flows must comply with these international obligations and constitutional requirements. And they must take into the account the proportionality test when applying this type of regulation to nonprofit sector. So for example, in practice, if we look at CAMA provisions and if we take into account that they do apply to nonprofit sector, it raises concerns over the compliance of such provisions with freedom of association requirements and standards, namely the ambiguity of reasons for suspending or removing the management and governance structures of the association, and the decisions on suspending these structures that are delivered solely by the government authority and not the independent judiciary. These provisions, for example, seem to lack compliance with the international standards of fulfilling the legitimate aim, and then also the standards for proportionality and necessity in a democratic society. Now, the ambiguous formulations that are too vague or that are too broad are of key concern. Also, the sanctions that such suspension of board members and their replacement applies must be based on the judicial review and not solely upon government discretion. They also infringe likely on the independence of the association to choose their own governing and managing affairs independently, and to address any mismanagement with its own procedures, as mentioned by Victoria. And these standards are clearly stated in the international documents, but also in the regional document, the African Commission on Human and People's Rights Guidelines on the rights to freedom of peaceful assembly and association. Now, how these regulatory attempts should be conducted? Well, we can follow the principles of a risk-based approach, which is a crucial element of the FATF and JABA requirements. And in a nutshell, that means, first of all, there must be evidence-based measures that are fully compliant with international standards of freedom of association, expression, assembly, and other rights. Second, there must be proportionality of these measures to the risk that is assessed for the particular sector, in this case, the nonprofit sector. Third, any mitigating measures and regulations that are being introduced and that impact the nonprofit sector should be developed with the engagement of the entire sector that is being affected. And finally, fourth, the sustained outreach to the civil society sector and the ongoing engagement and dialogue with the sector and with all parts of the sector that are affected is actually the way forward and the best measure and best insurance to have very effective anti-money laundering and counterterrorism financing policies in the country. And I'll stop here for a brief introduction, and I would be happy to continue discussing and answering the questions. Thank you.
Thank you so much, Vanya, and thank you also for being brief. I think it would help us with time for discussion. So I'm going to go right away and invite Sam Amadi from Bayes University to offer his perspectives around the link between the new law and constitutional provisions in Nigeria. Over to you, Dr. Sam.
Okay, thank you very much. I will just go straight to save time. First, like people have observed, the new CAMA obviously has some good, many good aspects in terms of streamlining the business corporate environment, streamlining process for incorporation, streamlining ownership, as well as making better provisions relating to degree of accountability, especially directors' obligation accountability. I think the primary area of conflict relates to management of NGOs, expectedly. 3 quick points I would like to make is that this debate should be situated around the notion that when we talk about incorporation is not an authorization for activity in terms of the rights of civic rights. So the Constitution has guaranteed persons 2 levels of right. One is a right to freedom of association and relationships, voluntary association by citizens. Section 40 of the Constitution is very clear on that. And of course, relating to freedom of religion, opinion, and conscience, Section 38. So what this means is that these rights are themselves executory. The Supreme Court holds that means they don't require further facilitation in terms of any law or regulation for people to exercise them. They are sufficient in themselves. And the only conditions in which they can be derogated from by laws validly made in a democracy, according to Section 45, that's the only condition for derogated for them. So these are primary rights, and that's very important. And now, so the idea of incorporation is to avail transactions of legal cover. So as we say in law, we are incorporated, you become a legal personality who can sue and be sued, who can own property, and of course can be recognized for other public benefits and also for accountability. But no registration does not vitiate or invalidate the rights that citizens have to associate themselves for civic or even cultural or religious purposes. That should be understood as we struggle with clarifying this legal regime. And the second point, therefore, is that the provision of the CAMA as relates to non-profit that's now possibly violates the Constitution. We're talking specifically of Section 839. Now, there are some confusion. Some persons wrongly assume that that section kind of authorizes only the courts can remove or appoint trustees, but that's not true. If you look at the section carefully, Section 8391 clearly is disjunctive from subsection 2. So either drafting error, but now that's what the law says. The commission by order, and don't forget that the commission is a regulatory agency that has both quasi-judicial and quasi-legislative and of course executive functions. So people get confused by the use of the word, the commission by an order. So they presuppose, maybe innocently, that word order means that it's an authorization by a court. It's not. The commission itself, as a quasi-judicial body, issues orders. So the commission by an order means that the commission can issue its order, and by that order, remove a trustee and appoint a trustee, an interim trustee. Now, what the first problem is that the CAC as a commission does not have due process protection, unlike a court. That means the Constitution, the CAMA did not provide procedural due process, meaning guarantee the right to a hearing, guarantee the right to evidence being provided, to even ensure that the action of removing a trustee, which is altering voluntary arrangements, is one that proceeded through a due process consideration. So that's really the first problem there. Subsection 2 empowers the court to now intervene. So two different tracks. the CAC can in-house by itself, through its own evidence or whatever, or petition, decide to intervene and remove a trustee. So the first question to answer is, should such power reside in a CAC that does not have, without a clear stipulation of due process protection for fairness and for justice? The second issue, therefore, is, if you look at the grounds, and I think the last speaker pointed about proportionality, clarity, the basis on which this power can be exercised against non-profits, against religious organizations, is the fact that the commission thinks there's a misbehavior, and again, for public interest. Now, that's too nebulous, meaning that there are no what you call intelligible principles or intelligible criteria that signals what would be public interest in this context. So these powers are ambiguous and broad, and the criteria for their exercise are not specified. Again, it's such that there's also, like I said, no provision for a requirement of fair hearing or even need to issue maybe notices, reaction notices, and allow the to be affected trustee or organizations respond. Again, the third issue is, it's very important that even though we classify non-profit to include secular NGOs and of course religious NGOs and religious institutions, but we need to make some functional separation here. The civil society has been defined classically from Hegel to all the persons to be between the state and the family. So everything that falls within that is a civil society. But not all of them really are in the same category. Why is it so? Because the freedom of religion, section 38, is guaranteed of opinion and of freedom of conscience. And because these religious institutions, whether they are churches or mosques or traditional religious group or even philosophic institutions themselves, deal with what you could call in political liberalism comprehensive moral doctrine, meaning that they are not just functional groups that are promoting particular public goods, whether education reform, whether social development, water, housing. They are involved in transcendental activities that deal with epistemology, deal with their religious invocation, and ritualistic practices that are peculiar to them. So membership is not just functional in the sense that you could, for example, Space for Change, you could take somebody from ActionAid to run it, assuming there's a crisis. You can say, okay, run it, because the goals are secular, their objectives are functional. So the argument is that asking that CSC in a country that has a history of intermingling politics and religion with all the anxieties and conflicts that arise from that, to empower without significant safeguards a commission, corporate management commission, to remove and replace trustees to manage epistemic, transcendental, comprehensive moral doctrine, manage institutions that are fully devoted to transcendental belief system, is terrible, because it could lead to, it doesn't make sense. So I think that she essentially will appreciate the concern of the religious organizations because of the history, Nigeria's history of some growing distrust of the social behavior of religious institutions. People don't get the argument. So we see it because they are not accountable, or the issues around corruption. We spoke about proportionality. These issues can be dealt with. If you look at the criminal code, if you look at the Nigerian, the EFCC Act, ICPC law, there are no exemptions from corruption, from crime, financial crimes, or other forms of bribery and corruption for religious leaders. So the accountability issues are the question here. they are supposed to be accountable for actions that violate the law, whether the kind of things that the Churches Commission in the UK has done with some Nigerian churches in terms of looking at their finances, in terms of punishing them, requiring payments and compensation, and even fines for atrocious accounting systems. So those should happen. But removing trustees of religious institutions is interfering into a very personal and transcendental area of citizens' life. And the starting point from a constitutional law point of view is that people assume it's not the government that has the responsibility to correct all ills. Some ills are corrected at the level of family, level of social groups, level of voluntary organizations. Government cannot, in the process of correcting all ills, invade private domain of civic right and freedom. And that's why the theory is the principle of government overriding public interest. So the constitutional law theory, both in the US, from US constitutional courts and Nigerian courts, is that before government can intervene, it should establish overriding public interest. And the question is, what would be the overriding public interest in removing trustees of voluntary associations that don't even need to register, except because registration gives them legal status to access some public benefits, to sue and be sued. They don't have to register. These are clearly voluntary associations that are in pursuit of constitutionally mandated, allowed religious, cultural, social values. So why would government intervene? So essentially, Section 40 of the Constitution that guarantees freedom of movement will prohibit, will be seen to be, the Section 839 of the CAMA would violate that Constitution. The only cutback in the Constitution is Section 45, and that cutback is very simple. It says that these rights guaranteed can be taken away, modified by laws that are proper in a democracy to protect national security, public health, defense, three considerations that constitute significant overriding public interest. So if you look at a case where perhaps we think that a trustee is not managing the trust well, government has no overriding interest in removing the trustee. Government has interest to ensure it enforces criminal codes, financial codes that relate to the public interest. Investors' confidence, if it's a corporate, a private or public company, even arrangement and compromise, the mergers and takeovers, receivership, things that allow you to deal with the functional aspect of company organizing without dealing with the right of citizens to aggregate, to associate freely and decide who runs them. So the argument here is that Section 40 does not even, Section 45 does not even avail government of regulating freedom of association of churches and mosques and even traditional religious associations. And so, both from the US case, there was a popular US case where some Nigerians, of course, who were a variant of cherubim and seraphim, who were using a particular animal as sacrifice in the religion. And the matter went to the Supreme Court, the US Supreme Court. The US Supreme Court even refused to strike down that practice because they established that there was no overriding state interest. The government has no overriding public interest to really deal with that. I think the case of Church of Lukome Babalu Aye against City of Hialeah, it's 1993 US Supreme Court case. But just the same point that the Supreme Court has made in Isabakova and DSS, that except there's an overriding public interest, you cannot override rights guaranteed by the Constitution. So I would argue that in as much as the CAMA, the purpose, the motivation behind the amendment is to streamline corporate governance, improve business environment, ease of doing business in terms of corporatization, and very good provisions. For example, a single individual can set up a company which in the era of looking for investment. It's a good news that foreigners can come and set up a company without looking for a Nigerian partner. So there are many good provisions, but the provision related to non-profit, particularly Section 839, creates a slippery slope that could lead to violation of the rights of citizens under Section 40, and particularly the right to freedom of religion and freedom of conscience and freedom of belief. And why this is important, if you look at the history of Nigeria and the recent events, we've seen persons convicted for blasphemy, we've seen persons convicted for all kinds of religious crime. And so obviously, the state religion relationship in Nigeria is very, very chaotic and could always lead to distrust, because there's always one allegation of either Islamization or Christianization. People are accusing the government every time of trying to undermine each other's religion. And so I think it's in the interest of the country and the constitution that CAMA, CAC, does not in any way deal with determining leadership of voluntary, especially religious organizations. That includes non-profits that are involved in secular activities, like all of us. And so let me restate the 3 points very quickly. First is that there is a right to freedom of association and organizing that is potentially threatened. Second, there's a threat to the freedom of religion and belief and conscience. And that the fact that this CAMA, the CSC, can interfere intrusively to remove and appoint trustee without any due process safeguard violates the idea of due process under the Nigerian Constitution, because that's why only the courts have done it before. Disputants of one region or another have gone to the Supreme Court, and the court has, through a due process framework, intervened in the management of religious groups. Why can the court do it and CSC cannot? Because the court has traditional, conventional safeguards. They're going to go through a trial, open trial. They're going to have lawyers. So if there are two members of NGO contesting about ownership or management of association, there will be process that gives guarantee that the courts will not act arbitrarily and the court will not be influenced by political consideration. But the CSC, neither the law nor the regulation, gives them such due process protection. And so their intervention will be seen as arbitrary and capricious. And finally, there is basically no public interest of overriding, that's the word, overriding public interest for government in order to deal with any transparency and accountability code to appoint or remove trustees. No overriding public interest. The state can manage possible violation of codes of corporate governance without removing or appointing trustees. Thank you.
Thank you, Dr. Sam. Thank you for your actually very incisive intervention. So we have some moments for questions. You can indicate by using the button for showing your hands, or you can also type your questions in the Q&A box. I have one general question for our panelists. Victoria and Sam and Vanya, any of you with views can chime in here. And that question is about the role of legal analysis or legal opinions in taking care of some of the potential risks that are foreseen in this particular law. Is there a role here? And as far as, Victoria, you were talking about different things that can be done as the way forward. What is the place of that kind of analysis, particularly with regard to interpretations? So Sam, you were talking about the question of making an order. I had to read that section a few times. And in fact, in my notes, I said, is there a word that is missing here? Or is that the order of CAC itself? So what is the role of legal opinions and analysis in kind of dealing with those things? Because you said it might have been an error. If we were to think about it as an error, what is the role that that kind of analysis can play?
go first. I can go. Should I answer? I can go ahead. Okay. I think, are you hearing me, by the way? You are? Okay. Why I use the word order, I would be sarcastic or perhaps cynical. Why I said, why is the word error? I was saying that I didn't expect it to be drafted that way, but I don't think it's an error. It's deliberate. Because what they have done, if you look at subsection 7, it restates that section 1 again, subsection 1 again, because section 7 also talks about further process for activating that one. Okay, so legal opinion, yes, of course. The thing is that first, if this section is not amended or somehow, and let's not forget, there's history to this. There was a code issued by Fiscal Responsibility Commission on code of governance for churches and religious organizations. I think 2 years ago, then under this administration. And I did a piece then and I argued that it was unconstitutional. And in the conflict, Buhari sacked the chief executive of that Federal Fiscal Responsibility Commission. And the idea has become fashionable. Either there's a social media freeze around the corruption and lack of accountability of church leaders and Muslim clerics and all that stories around it. So maybe this is what's driving this, that the CAMA CSC now wants to create some control. So legal opinion, maybe it's necessary in 3 ways. One is legal opinion as to the constitutionality of this provision. And so we have heard that some groups have hired very senior lawyers, and probably there will be legal context around whether the new CAMA is actually constitutional. There's also a subsidiary issue that the president consented after 3 months have lapsed, which the Constitution says a consent or refusal should happen within 3 months. So the validity, the legality, the status of that law could still be, the constitutionality of that law could still be questioned on many grounds. So I guess the lawyers who are collecting fees are already preparing briefs. Maybe they go to court. Then on a regulatory point of view, as a former regulator, I know that regulators, the US Supreme Court in the case of Chevron against INC, have argued that the regulators are masters of their act. So there will be regulatory interpretation. The regulators will also have a brief as to what does this law really mean. Probably they'll argue that this law predicates us to seek judicial order. But that would be very, very, very strange, because if you look at Section 2, Section 2 provides that based on petition order, court can now give an order to the commission. So there are 2 clear different channels: the commission acting and the court mandating the commission to take certain actions. So that Section 1 is created. Maybe many people think it's actually a mischievous provision to authorize actions that may be precipitate or actions that may be behind. For example, let's not forget religious group. It might actually be targeted at NGOs only, some troublesome NGOs. So they look at this NGO that is organizing protests against fuel subsidy, against blah, 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 abusing the president, issuing cartoons against president's wife and children. And they look at them as violating social media, what do you call it, social media law, or even violating the hate crime law. And on that basis, on public interest, decide to take out the stubborn founder of that NGO. So let's even not look at the church alone. This could be a threat, and that's what the problem is. At that point, so the legal opinion, they can see 3 types. One is that the one that lawyers would like to go and challenge the constitutionality of that bill. Second, legal opinion that probably will give guidance, legislative advocacy or regulatory advocacy, provide guidance to the regulators on how to proceed in managing this awesome power. And the third type of legal opinion will be the one that NGOs can get on what are the risk threats of this provision in terms of managing their entities, and so that you have clarity that, look, it can be pounced upon. So how should you protect yourself? What should you do to preempt such preemptive strike? And how could you go to court and get yourself out if you are unjustly, unduly, and unfairly removed as a trustee for any of these nebulous ground. So I see the three kinds of possible legal opinion in this regard.
Thank you, Dr. Sams. I have a number of hands up. I'm going to start by inviting, I'm sorry if I say the name wrongly, Goda Bapuji, to ask his or her question. Can you unmute this person, please, to ask their question? And Tim Nelaye, you can please be on cue to ask your question as well.
Okay, I'm trying to find him.
It should be right at the top of the attendees list.
Okay, I've seen. So, who is going first? Goda Bapuji.
Yes.
Okay. Okay, but you can talk now. Yeah. Goda,
Thank you.
You can speak now.
Yes. Hello, good afternoon. Thank you very much for having me here as part of the multi-stakeholder discussion. I am speaking from Cambridge, Massachusetts, USA at the moment. And I'm founder of one social organization called Women in Crisis Response. I did have a few questions after having listened through the dialogue. The first question is, what would be the impact for international NGOs who have regional offices in African continent? Because international NGOs have to report for accountability and governance also in their home countries. So there is a certain expectation of similar governance and accountability in all the other offices where such organizations operate. So it would be interesting to perhaps sorry if I say the name wrong, but Sam Amadi
Yes.
mentioned to maybe clearly specify within the CAMA law the provisions for international NGOs and how it would apply to them, or how it would be excluded for them. So that was one of the questions I had. The other question is, what are the alternate mechanisms that we could adopt perhaps as NGOs in our African continent to make sure we follow the governance and standards that governments expect of us, and also international bodies expect of us, to prevent money laundering, corruption, and other related crimes, and also terrorist financing. So it would be nice to perhaps consider something of ISO standards or something similar if we didn't want to take some of the provisions from the CAMA law. So perhaps CAMA law could provide such alternative mechanisms that NGOs could adhere to or certify themselves to. So I wanted to know what such provisions are made within the law, and could we perhaps advocate for such accommodations? Thank you.
Sorry, I'm going to invite Tim to ask your question now.
Okay. Yeah, Tim, you can speak now. Yeah, hello, Tim, you can unmute and speak now.
Okay, good afternoon or good morning, depends on where you are. Like you have rightly heard, my name is Tim Nelaye. I hope everyone can hear me.
Yes, I can hear you from here.
Okay, thank you. I would like to make a few comments and pose a question afterwards. I'm sorry I didn't join it early because I was joining from another meeting, so I didn't get all the discussions from the panelists. I got the last part of the second to the last and the last presentation. But from my point of view, the expectations and the targets actually within the areas of CAMA are basically two issues. The first one that deals with issues of a beneficial ownership information, While the second one deals with issues of compliance with regulations that deals with money laundering and the fight against terrorist financing. Particularly for the non-profit sector, is a sector that we are personally particularly interested in. What role do they play really in terms of concrete terms in engagement with relations that will influence money laundering and terrorist financing? Aside the speculation that the vulnerability of the non-profit organizations for terrorist financing, in concrete terms, we need to begin to define and show examples of their engagements in terrorist financing, which will point out to if others will be looking at possibilities of dealing with the concern that has been raised with this. As to religious institutions, I really don't have much interest in whether these things are applicable or not. But basically, if you look at the totality of the instrumentality of the work of the CAMA in terms of ensuring corporate governance structure is in place and is duly followed. To some extent, what we are facing is mistrust. And why are we facing this mistrust? Maybe previous behaviors of government, maybe cynicism that has been within the system, probably people have untold experiences in the past. And if these are the reasons why mistrust is being built over a period of time, to say, why do we have this amendment? Why are we covering non-profits or faith-based organizations? What exactly should government be doing to deal with this mistrust? Because you might find out that some maybe faith-based organizations or non-profit organizations that are vehement, that are carrying out high-level advocacy, that have high voices on issues that the government felt they shouldn't have, might be the reason why you might say at this point government have issues to them to ask to change leadership of such organizations. And I don't think this mistrust is unfounded. Therefore, what do we do really if we want this to stay, to deal with the mistrust that has been created over a period of time, and at the same time to ensure protection where government itself abuses its power when it comes to relations with other non-profit organizations or religious-based organizations? Thank you very much.
Thank you. I'll turn it over to our panelists to respond to those two questions, as well as the two questions that are included in the Q&A box. So the first one is, who determines that the trustees are in breach of the provisions of the CAMA law, given that the duties of the trustees the duties of the trustees are not the one that give them administrative control. I'm not sure, but I think, the first part of the question is clear. And then the second question is about, does the suspension of incorporated trustees and appointment of an interim manager mean the suspension of the governing body of the association, given that part F is about incorporation and regulation of incorporated trustees and not the registration or incorporation of the association itself. So if I can ask our panelists, Victoria, Vanya, and Sam Amadi, if you can really briefly respond to the questions that are directly related to your intervention.
Okay, sorry, I've been having like network instability. Can everybody hear me? Damazaki, can you hear me?
I can hear you, okay, yes.
Hello, Damazaki, can you hear me?
I can hear you, Victoria, yes.
Can you hear me?
Yes.
Yes,
okay,
we can hear you, we can hear you.
I've been having network fluctuations. So, okay, I heard the last question. That was Mr. Tim's question, Mr. Tim from Jeba. The question about where the trust issue, that the trust being well-founded, why is government interested in tightening regulations? I think at the beginning, I tried to say from my personal perspective what it is. I just want to go back to some of the things feeding the distrust and the analysis tensions between analysis arising from both sides. I will go back to the typology report on terrorism financing. I will also go back to NRA report of 2016. The typology report, that is JABA's typology report, which NFIU also quoted various sections that is almost adopted as its own. The 2013 typology report in particular, it identified non-profit organizations, among others, as a source of terrorism financing in Nigeria. Again, in 2019, Timothy Zawell and my colleagues from SCUMO, we did through a report where we were asking for evidence for that conclusion that NPOs are conduit pipes or vehicles for terrorism financing. Because when institutions, financial institutions make those statements, governments take them seriously. Even the typology report is supposed to be like a scenario planning report or case study. Government makes decisions on the basis of the conclusions drawn up in those typologies. So in our review of the evidence presented in the 2013 typology report, we found that the NPOs that were allegedly named or used in that typology for terrorism financing purposes, they had certain similar characteristics. Number one, they were all sham organizations, set up as terrorist organizations posing as legitimate entities. They were all located in areas of existing insurgency, particularly in the northern and southern parts of Nigeria. Then these typologies, they mainly involved NPOs acting in collaboration with sham entities outside jurisdiction. So we concluded that the terrorism financing trends and patterns in Nigeria, they established very few incidents and tend to use very isolated cases to generalize and propose drastic measures for the entire sector. And it goes back to what Brian was saying, that the government uses a one-size-fits-all approach, which is actually where this mistrust is coming from. So what actually do you think is the problem? Okay, we can blame FATF, we can blame JABA. Why? If you go back to JABA, they will tell you that their laws require governments to apply R8, which is a risk-based approach. And risk-based approach means that the government needs to take the entire, where, identify and classify the risk levels of different entities that are regulated. So the problem is that countries, not just Nigeria, countries don't know how to enforce R8. And that is that maybe many countries are constantly being rated non-compliant. So what can international financial institutions do to enhance countries' RBA enforcement? That is where the problem is. I believe that some of those threats are exist. I believe that there are concerns, there are security concerns, there are national security concerns that could exist here and there, but this is not the whole truth for the entire sector. So how do you now make government understand how to apply their measures in a targeted way that responds to the threats that they are trying to mitigate? So regulations have never been framed in a way that targets risk. Regulations have been made just for the sake of having regulations on the ground. And when you make regulations for the sake of having regulations on the ground, it gives authoritarian regimes the ample opportunity for us. So I think that is a response to Mr. Delay, what is feeding this mistrust between the NPO sector and the government sector.
Thank you, Victoria. Sam, do you have any response for any of the two questions that I've been asked? Please unmute your microphone.
Hello.
Hello. Can you restate the question again?
So the ones that are in the box, does the suspension of incorporated trustees and appointment of an interim manager lead to the suspension of the governing body? So that's the first. The second is who determines that the trustees are in breach of the provisions of section 839 subsection 1? So those are the two questions that are in the Q&A box. Okay,
the first question, no. The removal of a sub-trustee, don't forget that trustees could be more than two, and so you don't dissolve a trustee by removing one trustee. If all of them resign, or all of them are dead, or all of them are removed, then the trustee has ended. So technically speaking, the trustee remains, even though one of them have been removed, except there are only two. Again, the other quick question, but primarily the point is that if you remove the trustee, don't forget that the trustee can also be the management in the new law. So you can actually be a trustee who is also the executive director of the NGO. So if you remove him, then it could probably put in an interim person. It changes the dynamics of corporate governance and strategic management of the organization. The second question around who determines is actually the CSE. And let me just read it quickly what it says. Look at section 839 sub 1. The commission may by order suspend the trustee of an association and appoint an interim manager or managers to manage the affairs of an association where it reasonably believes that 1, there is or has been misconduct, blah, blah, blah. 2, that it is necessary to do so to protect the property of the association, to secure a proper application of the property towards the end. And 3, the problematic one, public interest. That means where it's necessary for the purpose of public interest or the affairs association has been badly run. Now, if you look at sub 7, like I spoke about, he also stated by saying sub 7, where at any time after the commission has made an inquiry into the affairs association, it's satisfied as to the matter mentioned in subsection 1, it may suspend or remove any trustee who has been responsible for a privy to the misconduct or management or whose conduct contributed to or facilitated it. Now, there's a very funny case here. Assuming that any in legal drafting in this case could mean more than 1, 4, 5, 10 people. So if the commission, so first the commission decides what amounts to either misconduct or what amounts to public interest. And this is important. The criteria of mismanagement of property or failure to apply property towards the mandate of the session is different from public interest. So the commission can remove the person for public interest on its own evidence, on its own body of evidence or lack of it. Again, the first question as to whether it can be dissolved, it amounts to dissolution. Now, assuming there are 3 trustees and the commission in its investigation decide that those 3 trustees are implicated, it says that any person who is responsible for or privy to the misconduct. So assuming they agree that the 3 of them are all involved in this misconduct, let's assume they issued a statement that is considered hate speech. Let's assume they took action that they think is against public interest. It means that they can remove 3 of them, and that will amount to technically, functionally, a dissolution of that. Because if the 3 trustees are removed, then that trusteeship, assuming there are only 3, and 3 of them are indicated, implicated, and removed, then that trusteeship cannot function. So the first question, whether it amounts to dissolution, depends, legally speaking, from the provisions, it doesn't amount to dissolution, but it can amount to paralysis, in which case nobody can function because all the trustees have been removed. The second question is that the commission can make this the decision based on its own evidence. There's no requirement of based on petition, based on court order. There's the second subsection is what the court can do. So the court can give direction to the commission to take action. But subsection 1, reinforced by subsection 7, stands alone, and therefore there's no requirement of evidence from anybody. The commission can make that based, it says when it thinks, based on its opinion, when it thinks that, it says where the commission by order, where it reasonably believes, that it's important to act on that, in that regard, it does so.
Thank you. So I think Vanya, did you have something to say?
Just very shortly, if you would allow me to address one very common misconception about the nonprofit sector and this type of regulation, that tries to combat terrorism financing and money laundering. There is a common misconception that the nonprofit sector has obligation to implement certain measures to fight money laundering and terrorism financing. This is simply not the case. The nonprofit sector does not have any such obligation at all. The governments have adhered to the standards from the FATF and other international bodies to protect nonprofit sector from the abuse of terrorist financing and money laundering. And while doing that, to actually make sure that they are respecting international obligations of human rights law and humanitarian law. So just to make it clear, the nonprofit sector does not have an obligation to actually implement anything. Yeah? The government does have obligations that they themselves adhere to. Having said that, there are, of course, different effective measures and mechanisms from the soft law perspective and self-regulatory perspective and internal mechanisms that nonprofit sector do apply in order to protect themselves. And these mechanisms work very well. In fact, the soft law mechanism, so-called soft law measures, which are the measures that are not actually the regulation, the hard law that the government adopts, they sometimes are even more effective than the blanket regulation that the government imposes. So educational activities, awareness, raising awareness campaigns among the sector, the promoting of good governance and financial integrity and procedures within the sector. Having in mind also that the sector is very, very diverse. So what works for very big, large, even international organizations that deal with a lot of incoming and outgoing funding does not work well at all for small or humanitarian or volunteer organizations that work specifically in one region or in one local community. So to conclude, there is no point in asking the regulator to prescribe what internal mechanisms NGOs or nonprofit sector should put in place in order to self-certificate or in order to have some self-regulatory mechanisms, because that does not work for the entire sector and it's not targeted, it's not risk-based. And again, the onus is on the government to protect the sector, not on the sector to implement anti-money laundering and counterterrorism policies. Thank you.
Thank you very much. Thanks to all of you for your very, helpful comments and responses. I'm going to ask if you can please stay on for the next round, because I think there are additional questions that have come up for this particular segment of presentations that I feel are important to respond to. But we will proceed to the next phase of presentations. And we have 3 speakers in this particular session that will be offering stakeholder perspectives. We have the Reverend Father George Etusani from the Luxtera Institute in Abuja. We have Bishop Olushola Ore from the Pentecostal Fellowship of Nigeria, Lagos chapter. And we have Dr. Abubakar Akali from the Bayes University Department of Petroleum and Natural Gas Engineering. I'm going to suggest that you keep your intervention to between 5 and 7 minutes. I know that you'd been told 10 minutes, but if you can keep it between 5 and 7, you would have a chance to say more during the question and answer section, but just to maximize the time, the shorter the intervention, the better. So I'm going to start with the Reverend Father George Etusani to give us his intervention. Over to you, Father.
Thank you very much. And I congratulate the organizers for this webinar and the speakers who have done very good job, done justice to the topic so far. I would just like to highlight a few of the issues mentioned, and I will make it short. One is that the apparent contradiction between Section 8391 and Section 8392. And as Dr. Amadi has demonstrated, Section 8391, subsection 1 and subsection 7 appear to make it clear that the commission is given these powers, this excessive discretion to using its own judgment, its own opinion, to suspend trustee and replace with an interim trustee, even though subsection 2, 8392 appear to give the powers to the courts. So there is a confusion, and that the clarification needs to be made very, very quickly, even while we are still discussing what to do about changing the law. Next is that, as somebody has also said, religious organizations would like to be excluded from the provisions regarding removal of trustees in the first place and replace with another, as Dr. Amadi demonstrated, because religious organizations are unique. They would like their peculiarities to be respected and not to be treated like just any organizations performing, setting up schools and setting up hospitals, which another person can be asked to head. Next is that there are internal corporate governance mechanisms in place in every well-established MPO. Now, first exhaust the procedures. The new law does not talk about how the internal governance mechanisms have been exhausted before the Corporate Affairs Commission takes action. If there is a crisis, if there is fraud, if there's accusation of some misdemeanor on the part of the management or the trustees of an organization, aren't there internal governance mechanisms for that MPO, which should be exhausted first before the government comes in? Then I would like to say that with the 1990 CAMA laws, sanctions or the implementation might have been a problem, but the regulations are all there. The regulations are there for the corporate governance of incorporated trustees. The regulations are all there. I think that right now, what some people have said about mistrust, I think it is real. It is real because we have to look at the context within which this law is coming. What is the context? 2016, it's about the NGO regulation bill, and then people cried and that one died. Then we recently heard about the hate speech bill, and now some of the provisions of that NGO regulation bill now appeared in this CAMA 2020. So there is a great measure of distrust between the government and the people being governed. One of the things we need in this country is to build institutions that are independent. We have a history of institutions that are not seen to be independent. They should not only be independent, but they should be seen to be independent. Unfortunately, in this country, the people do not see the superintending institutions in this country to be independent. And that's why there is an uproar when there is this kind of regulations. That yes, some parts of the CAMA 2020 are meant to ensure corporate governance, good corporate governance, accountability, and so on and so forth. But why was there such an uproar? Because there is no trust in government institutions, and that is very worrisome for our democracy. If in a democracy the people do not trust the institutions, then that is terrible. Finally, I would like to mention the processes of lawmaking in this country. I will count myself among those who belong to the elite in Nigeria. And I live in Abuja, and I had a leadership training foundation. How come I didn't know about the call for public hearing? I didn't know about the processes for this law emerging. And I'm not the only one. All the leaders of various MPOs that are complaining now, the lawyers that are complaining now, the church leaders that are complaining now, it means we did not know how this law emerged. And we are stakeholders who are supposed to have been consulted. We are supposed to have been approached and consulted to participate in these laws that will affect how we govern our entities, and we didn't know about it. So there is a problem with the processes of policy formulation and emergence of laws in this country that we need to look into seriously. Because if we just sat down and on August 7th, we hear that the president has signed into law such a bill, and then we began to see sections in the bill that affect our performance, our activities, then something is wrong with the processes of lawmaking in this country. I would end by saying that we definitely need to put some of these conflicting, controversial sections of the new law can be ameliorated. I mean, congratulations. Gap. To have full-time staff of NFIRS and banking regulation, we will need to have full-time staff to do all this. We are feeling overburdened in these circumstances, and yet these NGOs, these NPOs, governance has failed in this country. Thank you very much.
Hello, Dabazaki, are you there? Father, can you hear me?
Yes, I'm hearing you.
Okay, I think his line is freezing.
Okay, so maybe you call the next person. I thought I have finished my 5 minutes.
Yes, I think the next person, the agenda is Bishop Olu. I think it's Bishop Olu from the Pentecostal Fellowship of Nigeria, Lagos chapter.
All right. Okay, I'm here. Can you hear me?
Bishop Olu, are you okay? Yes, please.
Yeah.
Bishop Olu.
Thank you very much. Just like my Reverend Father has spoken, we want to thank God for the organizer of this program. I want to thank God for Madam Victoria and Dr. Sam Ahmadi. You've really done great work on whatever I wanted to say. But first of all, I'm speaking as the chairman of the Lagos State chairman of PFN. I'm not speaking for the national president, that's Reverend Dr. Felix Omabule, but I'm speaking for, in Lagos, and the concern of the Pentecostal brethren. So having said that, I would like to put it on record that there is no true religious leader that would be against probity and accountability. Many religious leaders, including our Muslim brethren and everything, there is a method, there is a program of accountability that many of us have put in place. And of course, in every organization, there are few people who will do something that is different from what they should have done. But that does not mean they should not be, because they want to prevent corruption or whatever they want to call it, begin to bring some laws that will stifle the growth and hinder the propagation of the gospel of Jesus. Now, you cannot control what you don't produce. And let me give you an example of the structure of PFN, the Pentecostal Fellowship, for example. A man goes to school, he studies, for example, I'm an accountant, and then we have so many people like that, and then suddenly you hear the voice of the Lord. Government needs to find out they need to know more about many of these religious organizations so that they just don't dabble into what they don't know anything about. And then suddenly God calls you to go and heed his call and go ahead on a full time. Many people don't find it funny leaving your corporate position, and then you go back to the scratch or to the ground, just like God told Abraham to leave where he is and go to a place that's going to show him. And then you now start that probably with your wife and your children, and then everything, many people, whatever they have, they want to put it into the ministry so that they can obey God and succeed in what God has called them to do. Suddenly, the Lord heard their prayer and the Lord reward their obedience, and he began to bless them and prosper them. And suddenly the government now comes and said that you have done enough. You have to retire, or you have to hand over, or some board, or so they are going to appoint interim whatever. So they need to know, and that is why you see the who and the cry, many people speaking. Well, I'm not really in support of some of my people who goes on online and get angry to the extent of insulting the government. But when you understand what it takes them to beat up that thing because they want to obey God, and then the government now want to interfere. And just like Madam Victoria said, you don't just go to one state or one country and go and copy what they are doing there. If the government gives me money, for example, I said, okay, I want to do a charity business, for example, and then the government give me money. The government has a right to find out from me how I'm spending that money. But if you don't give me money, for goodness sake, you don't have a right to begin to probe into how I spend the money you did not give to me. So this is the concern of the Pentecostal brethren, for example. And I think the government, we need to really sit down and just like Reverend Father said, we don't know when this thing was in public hearing. There is a way, and this issue of mistrust that we have mentioned, that we're talking about, I think the government needs to really look at that, because I mean, we don't know when this thing was in public hearing, and other people could have gone there to contribute. Well, I'm in Lagos, my father is in Abuja, and the public hearing is in Abuja. I did not even know anything about it. So I believe that the government needs to come open and find out from the people, maybe meet with the religious leader, for example. I mean, and find out how do you operate these things, and how should it be done. You just bring a law and then, and just begin to. So we are really concerned. The Pentecostal brethren, they are concerned and they are not happy about it. And I want to join Reverend Father to that. I think they should exclude, take us away from these non-profit organizations. I think that would be better. Thank you very much.
Thank you, Bishop Olushola. I'm going to turn the floor over to Dr. Abubakar to give his intervention. Are you there, Dr. Abubakar?
Unmuted him, but I do not know, maybe from his settings, but I've already unmuted him from here.
Dr. Abubakar, are you there? Okay, I'm not sure if he can hear us. Answer and discussion section, you can take his intervention. So if you have any questions, as with the previous occasion, please indicate by show of hands. In the meantime, I'm going to invite Dr. Bruno Nduka to give some remarks. Oh, Dr. Abubakar is back. Can you unmute your mic, please, Dr. Abubakar?
He's unmuted from here. Dr. Abubakar, can you speak?
Go ahead, please, Dr. Abubakar.
He's speaking, but nobody can hear him. I can see his mouth is moving.
We can't hear you.
I think his
Can
network
you maybe
is bad.
try to remove the earpiece to see if you would be able to?
I can go ahead.
Yes, go ahead.
Hello?
Yes, we can hear you now.
Okay. Okay, thank you. Thank you. Yes, thank you very much. I actually speaking from my own point of view, my own perspective. Obviously, I'm not, officially, appointed to speak for the Muslim community on CAMA 2020. So whatever I say here is obviously from my own perspective, my own viewpoint on what the issues are and how best we can move forward. Yes, from my understanding of CAMA 2020, the new CAMA law 2020, it's actually clear that there are some sort of complaints and apprehensions regarding the law. But I want to actually say one thing here, which is that from my own understanding, CAMA 2020 was actually not targeted, or is not targeted at any particular religion in Nigeria. That's from my own understanding. The constitution is clear in section 10 that Nigeria is a secular state. There is no adoption of any state religion. So from that viewpoint, whatever changes are made and whatever we have as CAMA New Law 2020 is actually an all-encompassing law, which is not targeted at any religion. Well, from the Islamic perspective, as far as I understand it, there is actually no no serious issue in this regard because Islam is a complete religion. All the patterns, all the ways of life of a Muslim are clearly defined in the Quran and the Hadith, and that is why Muhammad says anybody who produces anything, any sort of innovation, any thing which does not go in line with the dictates of Islam is rejected. Anybody who introduces anything which is in line with it, that is it.
Dr. Abubakar, I'm
so
sorry,
anybody who brings
really...
any sort of
Dr. Abubakar, can you hear me? I'm going to have to...
which is outside the dictate of Islam. It's rejected the Quran.
Abubakar, I'm going to have to ask you to...
should be that has been in detail.
Yeah, unfortunately, your connection is very poor and it's difficult to hear you, Dr. Abubakar. So we're going to have to move on to the question and answers. I'm really sorry about this, but we can't hear what you're saying. The connection is not very good. My sincere apologies. So if I can transition to Dr. Bruno Nduka, if you can give us your intervention in a minute or two. And if you have any questions, comments, if you can indicate by show of hands, as well as enter your question in the Q&A, whichever option you choose is fine.
Okay, thank you very much. Yeah, thank you very much. I have been listening to all the presentations and they are quite apt. And my concern is that Nigeria in particular, starting from what Madam Evelyn said about the mutual evaluation report and so on, that Nigeria has not been well rated and so on. We must know that the mutual evaluation as conducted require that the countries to demonstrate certain measures that they have put in place. And with respect to the MPO, it is the country that provides information. Like the NRA of Nigeria has already provided that the MPOs are at risk. But we need to know what is an MPO, because sometimes people are misplacing the church or the mosque with the definition of MPO. MPO is not the church. Like you cannot hold the Catholic Church now and say it's an MPO. But if there is an organization that the church is running for the purposes of other things, then you talk of that organization and not the main church itself. We need to understand that. And then I heard somebody saying that the MPOs do not have role to play in the implementation of EML/CFT obligation. When you go to recommendation 8 of the FATF 40 recommendations, especially under the methodology 8.3 and 8.4, you will see that the MPOs are also required to carry out certain functions. And that is why the government agencies will apply sanctions on them. The issue is whether those government agencies that are supposed to superintend over this are doing it as expected. And that is if they have been collaborating, because one of the questions that we should have in the mind is that both the government institutions and the MPOs should from time to time meet and discuss. I was happy that our Reverend Father raised an issue. When this CAMA was being reviewed, the question myself is asking, because I work in Senegal, is where were the organizations, all the religious bodies and other MPOs when this review was going on? Does it mean that the government or the National Assembly did not call for maybe public hearing? Was it just imposed? And at the National Assembly, we also have various groups of people from various religions. Did they not consult their various constituencies and so on to be able to get what should be right? So that we don't just copy. Because one of the questions we raise also in JABA is that countries will just come up with regulations, just copy from other organizations, countries and paste. But the FATA recommendation always say that you should adapt this to the peculiarities of your own country. So we need to look at all this from holistic angle. And if we're able to examine this, we'll be able to do well. But MPOs are required to actually implement some
Okay, I'm not sure if Dr. Bruno, have you finished your intervention? You seem to...
Yes, I've finished, please.
Thank you.
So can you hear me? Yes.
Yes, we can hear you. So there are a number of questions that are here. There's a question for the two questions that are here actually for the previous panel. So one question is to Dr. Sam, which talks about the trustee of an organization holding a management position. That does sound like a salaried position, and Shola Ulutai wants to know how that stands up in terms of the provision of section 238, subsection 2A. The other question is from James Savage, and talks about, if the CAMA law infringes on constitutionally protected rights to association, what action can be taken by the bodies that are responsible for these standards that CAMA is justified to be compliant to, and whether those bodies can press the government, as far as their international duties, to the extent that they devalue those standards that those bodies have set. So the first question is actually specifically addressed to Dr. Sam.
Well, thank you. Thank you. Well, the first question, I think he's right. Those trustees who could be in directing the organization are not going to be salaried, obviously. So because they're not going to, from the provision. So, but nothing excludes them from a trustee can be chief executive, can be director, but from the new CAMA, they will be reimbursed for expenses and other, so they say, but essentially they're excluded from being paid salaries, but the question is what is salary, what is expenses secured and all that. So they sort it out. Maybe when they start looking at the books, they'll be able to know which one is classified as salary and which is classified as expenses and allowances. Those are provided for allowed by CAMA. So essentially, they can be management, but not salaried. They're not staff. They don't hire a staff. That's the idea, because they are the legal owners and they are keeping a public trust. And the idea of a trusteeship is that they are not non-profit primarily, and therefore the promoters who become trustees are themselves not earning salary from the work they do, but they are getting reimbursed for expenses and maybe incidental expenses. Okay. But the second question around, well, of course, the fact that we say it's unconstitutional is still tentative, theoretical. Somebody has to go to court. So the NGO, the non-profit that's whose trustee or trustees are being removed, outsiders appointed into their board, has the powers, the legal status to go to court to challenge those decisions. So they can go to court. Public interest persons, based on the new fundamental right enforcement procedure rules to 2003 or 4, the private persons, anybody can go to court and sue against, as long as it's the protection of section 40 and section 38 of the Constitution. So the trust, the NGO can go to court, its members can go to court to challenge actions in this regard, and public interested persons, anybody who is publicly interested, can also go to court to challenge the law or possibly the action that CAC may take in furtherance of these provisions.
Okay,
thank you,
I would
Dr.
like to
Sam.
take the question from Mr. James Savage. I think I don't have the answer to that question, but I would like to just mention that the AML-CFT enforcement infrastructure at the national levels, I think is still evolving, and I think it's still developing, and accountability actually lies to nowhere. Why do I say that? If from what Mr. Bruno said, it's clear that the problem is that states, I think I did mention it before, states lack the capacity to enforce R8. That's just, states lack the capacity to enforce the risk-based approach. States are yet to understand what it means, what a targeted approach actually means, and how to apply regulatory measures to areas of risk. So I think that is why we're having all of this conversation. And if states are unable to do that, what can FATF do? What can GIABA do? The only thing they can do is to keep rating Nigeria non-compliant. I think together with members of the MPO coalition, Global Coalition on FATF, the last engagement we had with FATF in Austria, I asked that question: when you find that a state is not implementing R8 effectively, what should happen? And FATF doesn't now have the answer, clear and direct answers to that, because they cannot sanction countries for their inability to enforce R8 or RBA effectively. GIABA can only say, write them non-compliant. The state goes back and continue to tighten their measures to meet FATF requirements. So it's a vicious cycle that lies nowhere. So Mr. James, I think I wish I have the answers to your questions. We can press. From GIABA executives are here. They are very senior and very knowledgeable experts on AML-CFT. They understand the dilemma. So maybe from that angle and from their level, they can begin to advise governments accordingly on the need to make sure to strike a healthy balance within civic freedoms and implementation of regulatory measures that are consistent with AML-CFT and national security.
Thank you.
Over to you, Dawazaki.
I think his network is bad.
Okay, I think it's a bit frozen, but we're just taking questions. If there are additional questions, I think there is one from, okay, it's a conversation between Vanya and a team from Jabba.
I'm going to pass the floor to Dr. Abubakar to wrap this up.
Okay.
Dr. Abubakar, please.
Can you hear me now?
Yes.
Yes, thanks a lot. Yes, as I was trying to say before we had the connection issue, I'm actually not officially assigned to speak for the Islamic community in Nigeria. So whatever I say here is actually my personal view. It's only the the Supreme Council for Islamic Affairs in Nigeria that can take, a decision on the position of Muslims in Nigeria on the new CAMA law. But that said, I also have my own views regarding this. And to be honest, I don't see much of a conflict here because Islam is actually a complete religion. We have the Quran and Hadith that guide our day-to-day life from cradle to grave. So in that context, anybody who introduces anything, in terms of bringing in or defending some kind of personal interest or business interest or all of that, it is rejected, and that's what Prophet Muhammad taught us and said to us in Hadith number 5 that he who innovates something that is not in this matter, that's in the matter of Islam, it is rejected. Because my understanding of the new law is that it is actually communicated to check, that is, referring to section 839, subsections 1 and 2. They are actually meant to bring some form of control in the system. Of course, again, I would want to use this opportunity to say that from my own understanding, of course, the new CAMA law is not targeted at any particular religion. Section 10 of the Constitution is clear that Nigeria is a secular state. There is no set religion, and also the Constitution provides fundamental rights for association and practice of religion. So to that extent, I don't think the new law is targeted at any particular religion. Now, what is the law? What does the law actually say? What is the bottom line? There are two issues, to my understanding, which have prompted, debates, and also apprehensions. Which is that the Registrar General is actually empowered under Section 839 to administer some of these worship centers, and also to remove the boards of trustees, and impose, as it were, an interim management. So there is one thing in section 2 of subsection 2 of section 839, which actually I think is a window here, which is that the Registrar General cannot take such unilateral actions without a valid court proceeding and prosecution. So these matters are meant to go to court and to be deliberated upon. And so to that extent, I really don't think there is so much, there is a sort of unilateral power given to the Registrar General. And also, there are options, because of course you have to understand those who feel these issues are sort of one-sided. Or the options are that, as the Vice President said, we can actually, anybody who feels strongly those or these sections can propose an amendment at the National Assembly. But again, there is also another point that I want to state here, which is that, you see, government can actually, government is an enabler, government is a regulator. It's a regulator. I'm not saying that government should go into the nitty-gritty, but you also agree that there are actually some apprehensions on some individuals and even corporate bodies, you know, in the various worship centers, taking advantage of all of this. I just read things today of allegations of someone actually who used, you know, an NGO to launder money to the tune of about more than $40 million. There are issues of funding of terrorist activities. There are issues of money laundering and all of that. So to a good extent, the government has a duty. The government has a moral obligation to look at where there are excesses. I'm not speaking for government, but this is my personal view. The government has a duty to look at some of these excesses and say, okay, look, for the sake of control, these are the measures that are put in place. Because honestly, I don't feel there is any.
Sorry, Dr. Abubakar. I'm really sorry to interrupt you again for the second time. I'm really sorry, but we absolutely have to end this meeting at 5:30, just because it's over work time and some people have other meetings to get to. So if it's okay for me to interrupt you here and turn the floor over to Zikora from Spaces for Change to give us the closing remarks. I'm really sorry to interrupt you, but I want to make sure that we respect the time.
Thank you so much. Thank you so much, Dempsey.
Thank you.
Thank you, Lebezaki. Thank you, everyone, for finding time to join this session. I'm quite sure we've all had like an interesting engagement and found the presentations interesting and enlightening as well. We are very much indebted to our speakers, Madam Victoria Ibezim-Oheri of Spaces for Change, Vanya Skorik, Dr. Sam Amadi and Dr. Abubakar Akali, Reverend Father George Ehusani, and Bishop Olushola Ore for squeezing out time from their busy schedules to share their wealth of experience with us. I mean, it's a hope that we can take this conversation forward and continue together to work to defend the civic space. On behalf of Spaces for Change, I would like to say thank you to the Open Government Partnership team for their responsiveness and willingness to engage at a very short notice. It was indeed a very short time frame, and they responded to our call. We thank them for their listening ear and for their participation in this briefing, which has, as you all know, enabled the balancing of perspectives on a wide range of contentious issues that pose threats to the civic space as a result of the new revisions in the CAMA 2020. I cannot thank the Ford Foundation and the Fund for Global Human Rights enough for their consistent and immense support to Spaces for Change. We're very much indebted to them for their ever constant assistance at every point in time. They're always there, willing to hear us out and guide us and show the way forward. A big thank you also to the European Center for Not-for-Profit Law for some of the excellent insights that informed our briefer on CAMA 2020. Finally, I must acknowledge the members of the Action Group on Free Civic Space for their unified commitment to defending the civic space anytime. The Action Group on Free Civic Space is a valid testimony of the power of collaboration as members have continued to sustain their work seamlessly and leverage on shared resources to intervene in pertinent matters. Indeed, I must tell you all that the inspiration for our briefer on the CAMA 2020 stemmed from a compliance clinic, an anti-money laundering and counter-financing of terrorism compliance clinic, where members of the Action Group on Free Civic Space delved into an interesting discussion on compliance measures as defined by regulatory bodies and legislation in Nigeria. Special thanks to all local stakeholders and international stakeholders who found time to join this discussion. It is our hope that we can do this some other time and see you at that very moment. Thank you so much, everyone, for being part of this discussion. Thank you for finding out time to be here today. Thank you, Dabisaki, for an excellent moderation too.
Thanks all.
Thank you.
Have a good evening.
Thank you.
Yeah. Bye. Yeah.
Bye.
Bye.
Bye, everyone.
Yeah, bye.
And bye.
Before we do.